Good morning and welcome to the 32nd meeting in 2012 of the Finance Committee of the Scottish Parliament. And could I please remind everyone present to turn off mobile phones, tablets, Blackberries, etc. The first item on our agenda today is to decide whether to take items 4 and 5 in private. Are members agreed? Agreed. Members have indicated their agreement. Our second item of business is Stage 2 of the Freedom of Information Amendment Scotland Bill. We are joined for this by the Cabinet Secretary for Infrastructure, Investment and Cities, and I welcome her to the meeting. Good morning. Members should note that as officials cannot speak on the record at Stage 2, all questions should be directed to the Cabinet Secretary. Members have the marshalled list of amendments and the groupings. We will take each amendment on the marshalled list in turn. The running order is set by the rules of precedence that govern the marshalled list. I will call the amendments in strict order from that list, and we cannot move backwards on the list. There will be one debate on each group of amendments. I will call the member who lodged the first amendment in that group to speak to and move that amendment and to speak to all other amendments in the group. Members who have not lodged amendments in the group but who wish to speak should indicate that by catching my attention in the usual manner. The debate on the group will be conducted by me inviting the member who moved the first amendment in the group to wind up. I will invite the Cabinet Secretary to contribute to the debate just before I move to the winding up speech. Following debate on each group, I will check whether the member who moved the first amendment in the group wishes to press it to a vote or to withdraw it. If they wish to press ahead, I will put the question on that amendment. If a member wishes to withdraw their amendment after it has been moved, they must seek the committee's agreement to do so. If any committee member objects, the committee immediately moves to the vote on the amendment. If any member does not want to move their amendment when called, they should say not moved. Please note that any other MSP may move such an amendment under Rule 9, 10, 14 of Standing Orders. If no one moves the amendment, I will immediately call the next amendment on the marshal list. Only committee members are allowed to vote. Voting in any division is by show of hands. It is important that members keep their hands clearly raised until the clerk has recorded that vote. The committee is required to indicate formally that it has considered and agreed each section of the bill, and so I'll put a question on each section at the appropriate point. So, let's move to the business. Okay, I'd like to call Amendment 8 in the name of Elaine Murray and a group on its own. Elaine,
thank you very much.
Move and speak to the amendment.
Sorry, Convener. Thank you very much, Convener. During our consideration at Stage 1, I asked the Campaign for Freedom of Information to suggest any Stage 2 amendments which they felt that they would like the committee to consider. And I'm therefore very grateful to Carol Ewart of the campaign for proposing the amendments which are lodged in my name. And can I say also I am very grateful to Frances Bell of the legislation team for all her hard work in shaping and rewording the amendments, and indeed in doing so until the wee small hours to make sure they were in time for publication. Can I say that these amendments in my name are also supported by the Union Unison. Amendment 8, the Campaign for Freedom of Information Scotland has argued that the public's right to know now is far weaker than when the legislation was passed in 2002, because Section 5 of the Act has never been used, and at the same time a variety of different bodies are no longer within the remit of the Act. A number of freedom of information laws around the world contain a purpose clause, for example New Zealand and Canada, both of which were used to inform the drafting of this amendment. The Campaign for Freedom of Information considers that a purpose clause is necessary as the Freedom of Information Scotland Act has not operated in the way it was intended. Many of the bodies created by public authorities since 2002 are not now covered by the Freedom of Information Scotland Act. Parliament needs to be clear in its expectation of the Act and of public sector bodies, and CFOIS wants the rights to be retained. Therefore, when the newly created bodies should be subject to the Act as well. Amendment 8 aims to achieve an increase in the availability of information and also reflects recent commitments on the transparency agenda. It does so by introducing the purpose clause into the Act, which would mean that the public's right to know would remain effective, even if delivery of public services changes in the future. The purpose clause reiterates the 3 founding principles of the Scottish Parliament: openness, accessibility and accountability, and requires the availability of information held by Scottish public authorities to increase progressively rather than to decrease, as has been the case over the last 10 years since the Act was passed. This requirement promotes public participation, the accountability of public authorities, and facilitates informed discussion, thereby improving governance. The purpose clause also confers an enforceable right to access information by the Scottish public in relation to all public services and services of a public nature. And I move amendment number 8.
Thank you. John Mason.
Thanks, Convener. I mean, I do have some sympathy with what Elaine Murray is saying, and I think we probably all of us agree on the principles of openness, accessibility and accountability and these things. And if you were starting to write legislation from scratch, I would kind of agree that we should have a purpose clause in it. I think to add a purpose clause in, though, as an amendment, I have reservations about, because it changes the whole fundamental ethos of the Act, and obviously of the amendments as well. So I think because we are where we are, we're amending existing legislation, I think I would just express reservations about bringing in a purpose clause at this stage.
Cabinet Secretary.
Can I say, firstly, I've listened very carefully to the committee at stage 1 on this bill, and I will continue to do so. Also met last week with the Campaign for Freedom of Information, and what I said to them is the same that I'll say to the committee just now, even where I'm asking, as I will do on this amendment, the committee to reject amendments this morning for very specific reasons. I will continue to look at scope for bringing forward amendments at stage 3 that try to encapsulate the views of the campaign and the views of the committee where that is, I think, possible. Amendment 8, specifically, as Elaine Murray has said, advocates the insertion of a purpose clause. Like John Mason, I'm not unsympathetic to the thinking behind this, but I question both the necessity and, perhaps more importantly, I'm worried that an amendment like this, introduced as an amendment, as John Mason said, might lead to unintended consequences. I don't agree that such a clause is required for the legislation to continue to deliver on its underlying principles. As a matter of good lawmaking, I think if the Act was failing to deliver on those principles, which I don't accept that it is, the proper way to address that would be through careful amendment of the Act's provisions rather than overlaying it at this stage with a purpose clause, the effect of which would be uncertain. There's also real potential for such a clause to cast doubt on how the Act operates with unknown and potentially unintended consequences as to the operation of the existing legislation as a whole. I think whatever frustration there might be, and I recognise the frustration about the failure to date to extend the Act and to designate new bodies, I don't believe the weakness in the Act is down to a lack of clarity about the purpose of the Act. I think the purpose of the Act is actually very clear. If you look at the long title, it already states that the Act makes provision for the disclosure of information held by Scottish public authorities or by persons providing services for them. Section 1 of the Act itself states that a person who requests information from a Scottish public authority which holds it is entitled to be given it by the authority. And even if you look at application of the public interest test, there's an underlying presumption in favour of disclosure. I think it's also important to note, although we shouldn't, and the committee shouldn't necessarily be bound by this, but back in 2002, the report of the lead committee, when the bill was going through that became the Act, looked at and decided that it was not persuaded at that time of the need for a purpose clause. So that's my reasons for saying that I don't believe this is necessary, which is not the same thing as saying the Act and how the Act is being applied is perfect. But I guess my fundamental objection to this amendment goes to the points made by John Mason. I worry about the unintended consequences of overlaying an existing Act by an amendment to an Amendment Act with a purpose clause, without having very full consultation and scrutiny and consideration of what those consequences might be. I mean, if you look, for example, at the existing Act, it's been the subject of considerable interpretation and implementation by the Information Commissioner, and it's been subject to substantial consideration by the courts. If this purpose clause was added at this stage, the Information Commissioner and the courts would have to reconsider the meaning of all provisions in the Act against the new purpose clause, and that, I think, would introduce a substantial degree of uncertainty for authorities and for the public who would wish access to information. I think adding that kind of clause in this manner would be unpredictable because it could lead to the Act being interpreted in a manner very different to the manner in which Parliament originally intended. And as I said, we would be doing so without the normal consultation and proper in-depth scrutiny of what those consequences might be. So for these reasons, while not unsympathetic to the motive behind this amendment, I would ask the committee to reject this amendment. As I said earlier on, and we'll come on no doubt to touch on the issue of extension in further amendments, I recognise that frustration, and I've certainly got a willingness and a determination to address that, but I don't believe the way to address that is through a purpose clause, which A, is not necessary, and B, could have quite significant unintended or at the very least unpredictable consequences.
Yes.
Point of information on that. In terms of the unintended consequences in having to reconsider all provisions, would it actually imply that some of that might be retrospective in terms of having to reopen all cases? Or?
No, that's not what I mean. What I mean is there is case law already, both in terms of court case law, but also decisions of the Information Commissioner. I'm not suggesting that those already decided cases would have to be reopened, but in future interpretations of clauses of the Act that are perhaps well understood and settled would have to be looked at afresh in light of a new purpose clause. So unintended is perhaps not the best word. Unpredictable, I think, is the better word. We don't know what that would mean in terms of settled interpretations of aspects of the Act. And, you know, if Parliament is going to do something like that, I'm simply saying that I think there is a better, more considered way of doing it than introducing it as an amendment to an Amendment Act. I do believe doing it in this way would have potentially those unpredictable consequences. And I also think that the frustrations about the Act, while I recognise them, I don't believe they stem from a lack of clarity about the purpose of the Act. They stem from the so far unwillingness of successive administrations or failure of successive administrations to use powers in the Act to extend the coverage of it.
Okay, Elaine Murray, to press or withdraw your amendment.
Right, given that I appreciate what the Cabinet Secretary is saying about the unpredictability of interpretation of the Act, particularly as this amendment only arrived on the last day of publication of amendments, so there hasn't been much opportunity for the Information Commissioner or anybody else to actually consider the implications of it. So in that case, I'm certainly happy to withdraw the amendment at this point.
Okay, thank you very much. I now call Amendment 1 in the name of the Cabinet Secretary and a group of its own. Cabinet Secretary to move and speak to the amendment.
This amendment addresses what undoubtedly was one of the most contentious provisions in the bill. In my response to the committee's Stage 1 report, I set out the government's reasons for proposing that information relating to communications with the current and future heads of state should be given additional protection. I won't rehearse all of those arguments, but in summary, it was to ensure consistency of approach across the UK to the handling of the same or similar information, and it was in the interest of safeguarding the political neutrality of the monarchy by providing appropriate regard for the confidentiality of communications between Her Majesty and Scottish public authorities. As I noted previously, many access to information regimes contain protections tailored to their nation's head of state. However, I said at the time of the Stage 1 debate and in reflecting on the very clear view expressed by the committee in its Stage 1 report that I would give further consideration to whether the existing public interest test provides adequate protection. I would look at how the royal exemption has been applied in Scotland and whether experience in Scotland in fact necessitates the same approach is now taken elsewhere in the UK. So I've had that further consideration, and my conclusion is that this part of the bill is not strictly speaking necessary. The exemption is seldom applied, and though it's very rarely been tested, it's generally fully upheld by the Information Commissioner. I also note the original understanding in terms of what constitutes an absolute exemption, that these are of an essentially technical nature and support the effective operation of the legislation. So my decision to lodge this amendment to remove Section 1 of the bill takes into account the views expressed during consultation, during the committee's consideration and during the Stage 1 debate. We will continue to apply the exemption in the interest of protecting the constitutional position of the monarchy and in full regard of the established conventions of confidentiality, in particular in respect of communications to and from Her Majesty. However, I am persuaded, I have been persuaded, not least by the committee, of the importance of retaining consideration of the public interest in relation to disclosure of this class of information, and I therefore move Amendment 1.
Okay, Gavin.
Thank you, Convener. There's a strong and compelling argument that the arrangements for dealing with communications between the monarch and the Prime Minister's office should be the same as the arrangements that pertain to communications between the Queen and the First Minister's office. The point about consistency is important. I will say it would be strange to have a situation in which communications between the monarch and the Prime Minister were treated differently from communications between the monarch and the First Minister. That's the motivation for the change. The consistency argument that I have given is the foundation for that, and I think that it is a strong one. It would be odd, to say the least, to have different positions, and it goes to the fundamental nature of relationships. I've given you what I think is a strong reason for the change that we propose. Convener, everything that I just said, it was said by the Cabinet Secretary a few short months ago to this committee, telling this committee why Section 1 of the bill was important and ought to be included. And I have to say I was persuaded by the Cabinet Secretary at that time. I agree with her, or agree with what she said then, that the point about consistency is important. And on that basis, I would encourage members to vote against this amendment, and I would encourage the Cabinet Secretary not to press that amendment. Thank you.
Elaine Murray, to be followed by John Mason.
Here I must disagree with Gavin. I'm refreshed by the fact that the Cabinet Secretary was prepared to listen to the arguments put by the committee and the majority feeling of members of this committee, which also reflected strong evidence we had received during the Stage 1 process. I think despite the desire for consistency, where the UK Parliament has passed legislation which is inappropriate, and I understand from others was not fully discussed prior to its passage, that it would be folly for the Scottish Parliament to go down the same lines.
Okay, John, to be followed by Jamie.
Thanks, Convener. I mean, I wasn't actually going to speak on this amendment because I'm perfectly comfortable with it, but I just was slightly wound up by Gavin Brown's comments. And especially the fact that he was persuaded by the Cabinet Secretary's arguments, whereas I think he'd made up his mind previously, as far as I'm aware, and wasn't perhaps even at that particular meeting. No, I mean, I think I would just like to say, echo really what Elaine Murray just said, that I'm very encouraged that the government, and particularly the Cabinet Secretary, has listened to the arguments on this. It wasn't just from this committee. We were reflecting largely views that we were getting from outside. I think sometimes there has been criticism of the committee system in the Parliament. I think this is a good example where the committee has taken a firm line, and it is also a good example where the government has listened and responded, and I think this is to be commended.
Thank you, Jamie.
Thank you, Convener. Of course, I wasn't a member whilst of the committee whilst it took evidence on this particular issue, and undoubtedly I'm sure there might be an argument for the position that was previously advanced by the Scottish Government. I have to say I'm instinctively uneasy about the application of absolute exemptions generally in terms of any freedom of information legislation, and whilst I hear the argument had been advanced that the UK has a position, I'm not necessarily convinced that just because the UK has a certain position it follows that the Scottish position needs to be by necessity the same. And clearly there has been a body of evidence presented to this committee, and I think it is, and I think the government should be congratulated for having listened to the committee position, notwithstanding the fact I wasn't on the committee when it took the evidence on that position. On that basis, I think we should support the Cabinet Secretary's amendment.
Thank you. Cabinet Secretary, to press or withdraw your amendment and wind up.
Well, can I say to Gavin Brown, there is a strong argument for the view I articulated at stage 1, but there's also a counter argument, and that counter argument was put, and I've listened to that. Members of opposition parties frequently say the government should listen more to committees. I do take the views of committees very seriously, and on this occasion I think the committee was right, and it was reflecting opinion that had been put forward. I think the final point I would make is that having, and this really I suppose is where my reflection took me, having these different processes in place north and south of the border doesn't actually inevitably lead you to an inconsistency of outcome, because there will be many cases, and the limited experience so far shows this, that the application of the public interest test will lead to communications with the monarchy remaining confidential, but that has to pass a public interest test, and I think that is appropriate, and I think that is the right balance to be struck. So for all of those reasons, I'll press the amendment in my name.
Thank you. The question is, Amendment 1 be agreed to. Are we all agreed? Yes. Agreed. We are not agreed, therefore move to the vote. All those in favour of Amendment 1, please show hands. All those against? The vote is 5-1 in favour. The amendment is therefore agreed to. I'd like to call Amendment 2 in the name of the Minister, grouped with Amendments 2A, 2B, 2C, 2D, 2E, 2F, 9 and number 7. And just before the Minister speaks, I just want to point out that members have already been informed that the presiding officer is determined under Rule 9.12.6c that should Amendment 9 be agreed to, the bill would require a financial resolution. As no resolution has been agreed to, Amendment 9 may be moved and debated, but I will be unable to put the question on that amendment. So, Minister, to move and speak to Amendment 2 and all amendments in the group, to be followed by Elaine Murray.
Thanks, Convener, and apologies for perhaps lengthier comments, because I'll try to cover all the amendments in the group at this stage. I consider the issue of extension of coverage to be separate from revising the Freedom of Information legislation to ensure it remains fit for purpose. And the approach of the government has always been that we will return to the question of extension once this bill has completed its parliamentary passage. However, I do appreciate very much that the failure to so far extend has disappointed a lot of people who see extension of coverage as a closely related aspect in ensuring that the legislation remains robust and fit for purpose. So of the two issues that have created most debate around this bill, extension is undoubtedly the more substantive one and the one that has greater long-term significance. Critics note, and they note rightly, that there have been 3 consultations on extending coverage, and that from before the Act came into force there were high expectations that the Section 5 power would be used at an early stage, and that hasn't proved to be the case. I fully accept that one way that Scotland can, and indeed must, seek to maintain its reputation for progressive freedom of information rights is by regular assessment and, where necessary, use of the power to keep coverage of the Act up to date. The mechanisms through which public services are delivered are changing rapidly, and that's something the committee certainly commented on at stage 1. The legislation must keep up to date, and to be perfectly frank about it, the legislation has not kept up to date with those changes in all respects. I said at stage 1 that I do intend to bring forward an order for extension in early course, and I will say more about the coverage of that order at stage 3 of the debate. If I can turn to Amendment 2, which was developed from proposals put forward by the Information Commissioner, it seeks to ensure appropriately focused consultation and that ministers are made clearly accountable to Parliament in regard to its use or otherwise. It allows for more extensive consultation than is provided for in the Act, without necessarily mandating full public consultation in every case, because that will not always be appropriate or proportionate. And in terms of reporting, it seeks to strike a balance, and strikes that balance at 3 years. That, I should stress, doesn't mean that an order or only one order can be passed once every 3 years. What we are seeking to do here is have a timescale that will enable an appropriate consultation to be carried out on a draft order, as well as appropriate time for scrutiny and consideration of any such order by Parliament. And the report can and should give full clarification on how and why the power has either been used or not been used, and include a helpful indication of any intentions to use the power. I consider both measures put forward by Amendment 2 in terms of both consultation and reporting on use of the Section 5 power to be responsible and proportionate. Again, I absolutely accept and have sympathy with the approach behind Elaine Murray's amendments, but I think the approach taken in the government amendment is preferable to Elaine Murray's amendments, which I think in certain respects are ill-defined and in other respects overly bureaucratic. If I can just take them in turn. 2A removes a standard consultation obligation and replaces it with an obligation to consult the public and other interested parties. Other interested parties are not defined, and it begs a question: who are other interested parties that are not otherwise members of the public? What does interested mean for the purposes of this particular provision? What would be the consequences if someone who's not been consulted later asserts what they describe as an interest, and how would that interest be defined and adjudicated on? Amendment 2B, I would argue, is unnecessary, not wrong, but unnecessary. It is already a matter of administrative law that due regard is given to the results of consultation, so it adds little, in my view, to restate an existing obligation of ministers and legislate for that in the face of the bill. The purpose of legislation is to change the law. This amendment would not change the law because administrative law already requires ministers to take give due regard to the results of a consultation. If I can turn now to Amendment 2C and the proposed timescales within that, they would mean that within a 2-month period of commencing this provision, the first report would be due. I don't think that is appropriate. We all know the position right now. The power hasn't been used. I'm not sure we need a report in a few months' time to tell us that. The provision we propose of 3 years is designed to better align the reporting period with the lifespan of a parliament, which will appropriately cover any consultation period and subsequent orders made within that timescale, which I think is a more reasonable approach. And I again would stress it doesn't mean that an order won't be passed before then. Indeed, as I noted earlier, I've already said that we will be bringing forward an order and that I'll give detail of that order at stage 3. Amendments 2D and 2F require an annual reporting. I think that would lead to an never-ending cycle of reporting without adequate time within that for due scrutiny and consultation and consideration. Amendment 2E, I think, is unnecessary. If we've consulted, we're likely to report on that, particularly as our own amendment requires us to state whether the power has been exercised during the reporting period. If I can turn now to Amendment 9, Convener, and I note your comments that this amendment will be debated today but will not be voted on due to the decision of the presiding officer that it requires a financial resolution. I do think this is the amendment that really does or would result in bureaucratic overload with a lot of confusion on top of that. There appears to be a lot of overlap between Amendment 9 and Amendment 2, but it still appears to do different things, and perhaps Elaine Murray will clarify how those amendments would fit together. Amendment 9 requires annual reports to be laid regarding the exercise of the power to extend the coverage and for draft instruments to be laid following each report. It similarly requires a report to be laid shortly after the commencement of the provision, which, as I've already explained, seems of little value. And in one reading, it would require 2 reports to be laid in a very short space of time. Amendment 9 creates an obligation on ministers to firstly report and then to designate bodies every year. It's not clear to me how this interfaces and how this would sit with the need to carry out proper consultation, including building in appropriate time periods for that to take place and indeed time for ministerial decision. Are we really saying that it will always, every single year, be appropriate to use the power? How do we know that there won't be years when we've reached the point where there are no bodies that are appropriate for designation? An instrument laid so soon after the report is hardly, in my view, a recipe for appropriate scrutiny and reflection. And I think it would lead to an extension process becoming automatic rather than one that is the result of deliberation and proper consideration. Amendment 7, finally, convener, is a technical amendment to the long title of the bill to reflect the provision concerning the power to designate authorities in Amendment 2. So what I would conclude by saying is that Amendment 2, in the name of the government and all of the other amendments in this group that Elaine Murray has raised, are in many respects trying to do the same thing. I would simply argue that Amendment 2 does these things and achieves these things in a proportionate way that builds in sensible timescales, but crucially allows appropriate opportunities for Parliament to scrutinise and for ministers to consider decisions with the due care and attention that they require to do that. So I hope, I look forward to hearing Elaine Murray, and I hope I'll be able to persuade her to support Amendment 2. And I move Amendment 2.
Okay, thank you. Elaine Murray to move and speak to Amendment 2A and other amendments in the group.
Can I first of all say that my amendments, or the majority of my amendments, are actually amendments to Amendment 2, and I indeed do welcome Amendment 2 and its provisions. These other amendments are just intended to discuss whether it can be pressed a little further. Amendment 2A replaces the requirement of Scottish ministers, as the Cabinet Secretary has said, to consult such persons as they consider appropriate with the public and other interested parties when designating the authorities to be included in the Freedom of Information Scotland Act. And I hear what the Cabinet Secretary says about the definition of other interested parties. That actually arose because there was a concern from the campaign from Scottish for Freedom of Information Scotland that they would not be covered by the term members of the public. And I think if the Cabinet Secretary can confirm on the record that the terminology used in her amendment would actually cover such bodies, we would be able to reassure them that they would automatically be consulted in the terms of Amendment 2. Amendment 2B requires ministers to have due regard to the consultation responses in deciding how to proceed in relation to the proposed order. Again, I think in the Cabinet Secretary's response to that amendment, she has put on the record the fact that this is a requirement already in law, and therefore I don't intend to press that amendment further. Amendment 2C requires a first report on Section 5 power to be laid on or before the 30th of June next year rather than 2016. And members of the committee will be aware that the Information Commissioner had also raised concerns about the length of time given an Amendment 2 before a report has to be laid. As currently drafted, the first report would not be presented to Parliament until 14 years after the Act was passed, and we should perhaps recall that at the time the Act was passed, the Justice Minister, Jim Wallace, promised early consultation on the extension of the Act to cover RSLs and companies involved in major PPP, PFI projects. So progress to date has been fairly slow. It may be that 2013 is too soon, but it could still be argued that 2016 is too late, and perhaps there is a room in there to, for a compromise. As the Amendment 2D and 2F require annual reporting rather than reporting every 3 years, and that is offered in order to ensure that agreed timelines and the strength of the legislation will be retained. Amendment 2E expands a provision that the report summarises the responses to any consultations carried out on the extension of Section 4 power, with a requirement to report more broadly on whether any consultation has been carried out, also to summarise the responses and to explain how the responses have been taken into account when a decision was made on whether or not to extend the Section 5 power. This is intended to make the process more transparent and to eliminate the government's reasoning, and in that way the public can be reassured that the correct process was undertaken diligently, even if the public disagree with the conclusion of the report. Amendment 9 has been a difficult one. CFOIS proposed this amendment because successive ministers have undertaken consultations which repeatedly supported additions but were not actioned. The Scottish Executive consulted in 2006, but subsequently declined to act, and they promised further consultation. A discussion paper was launched by the Scottish Government in 2008. A consultation was issued in 2010, which commanded wide support for addition of new specified bodies. But to date, no timeline has been published to add new bodies, and no action is expected until next year when the current bill has been passed, and this indeed was confirmed recently by the First Minister. This amendment requires Scottish ministers to be proactive on their designation and to set out timescales for action. CFOIS wish to see designation of those public authorities already subject to consultation in 2010 and action on further designation. Now, the amendment obviously was drafted by the legislation team who put in a fair amount of work to try and reflect, I think, what was a policy intention presented to them to try and interpret that into legislation. And that I think, is probably the cause of some of the way the duplication. It was difficult, I think, a difficult task to try and find an appropriate legislative way of interpreting that policy intention. They wished the amendment to act in three ways: setting out a timetable for designated public authorities to be covered by the Act, drawing up a second list of organisations to be covered by the Act, and then embarking on a third consultation on a new list. They, for example, cite the fact that the 2010 consultation included the Glasgow Housing Association, but not other registered social landlords. This amendment requires a draft statutory instrument to be placed no later than 20 days after the report setting out the proposals for exercise of the order-making powers, requires the first report to be laid on or before September next year, and subsequent reports to be laid annually. In effect, this was intended to ensure that at least one public authority was designated each year, except under exceptional circumstances, which ministers would be required to provide an explanation of these circumstances. As we know, of course, the presiding officer has advised that this amendment would require a financial memorandum to be provided by the Scottish Government, and therefore it can only be debated today, and the question cannot be put. Again, because of the difficulties, I suppose, in interpreting the policy intention into legislation, I'm interested to hear the comments of committee. The question will not be put, but the possibility of seeing whether some of those intentions can be translated later at stage 3 would be useful if members are so desiring.
Thank you. John Mason.
Thanks, Convener. I mean, again, just first of all, I think to welcome the Amendment 2 and the fact that, once again, the government has listened to what the committee was saying. I think at Westminster I served on 2 public bill committees, and I don't remember any significant compromise on the part of government at the committee stage. I think specifically 2 is welcome in that it definitely strengthens the overall position and the reporting back to Parliament. So I'm certainly supportive of that. On the specifics, Elaine Murray's Amendment 2A, I mean, frankly, I think both the government's amendment and Elaine Murray's amendment are actually quite weak. When we look at what it says also consult such other persons as they consider appropriate, which, frankly, I'm not sure means very much. But to replace that with members of the public and other interested parties, I'm not sure means very much more. So I have to say I'm not enthusiastic about either wording, but there we go. I think the point, both Nicola Sturgeon and Elaine Murray have kind of accepted that 2B doesn't really add very much. I mean, I think the whole thing about consultation with the public is an interesting one, because I think some of the public view it as a kind of voting contest or a referendum, and that those that return the most responses should be listened to, and I don't think that actually should be the case. There would be very little point having a consultation if ministers did not listen to it and have some regard, and I don't see that actually writing that down makes a huge difference. I think the one I'm most sympathetic to of Elaine Murray's in this batch is 2C, taking 2016 and replacing it with 2013. Now, I accept Nicola Sturgeon's point that 2013 is probably too close, given the way this legislation is going. At least, I think it would be, June 2013 would certainly be too close. But I do wonder if the Cabinet Secretary would maybe consider whether it could be brought forward a bit from 2016. I think if we were starting from scratch again, that might be acceptable, 3 years. It's just because of the history of this and people have felt it has been delayed so long that there might be an opportunity for either 2014 or 2015, both of which would have the advantage of being in the life of this Parliament, as I understand it, because if we're on to June 2016, we're past the next election, which might be a slight disadvantage. Again, on 2D, I take the arguments on both sides. 3 years is quite long, 12 months is too short. Is there any possibility of a compromise, maybe at 2 years? And I think, actually, that's probably all I want to say. Thank you.
Okay, Jean Urquhart to be followed by Michael McMahon.
Thank you. I would just like to support the 2C and 2D and ask that could be considered. It seems a long way in the future for people. And my question really is in terms of the letter from the presiding officer and the financial implication. And it's maybe something I'm just not understanding, because I have sympathy for Amendment 9, in terms of other organisations. But it seems to me that the ALOs particularly are really all of the work that was done previously to the ALO being established was actually eligible to freedom of information as part of local authorities' everyday work, if you like. Most of the ALOs are set up to run leisure activities or arts and so on. So it seems to me that there would be no financial implication with that. Am I being naive? And should that be, in that case, should they particularly be separate from consideration of other organisations, housing associations and so on, or would that be the same thing? I can't quite understand.
The position that we're in is that the presiding officer ruled that we can't actually move on it, so we can't move on it. It's as simple as that, you know, and I don't really see that there's any real point in actually debating that issue further, given the fact that we can't take it forward. But that doesn't mean that the issue can't be raised again at stage 3. Michael.
Thanks very much, Convener. Can I start by apologising for my late arrival? It just seems that every Wednesday morning, every broken down lorry, the central belt seems to arrive on the M8 in front of me, so my apologies also to the Cabinet Secretary. Again, just reiterating Elaine Murray's comments around Amendment 2, that there's essentially nothing wrong with it, but some clarification around its intention I think would be helpful, because there are some concerns that it doesn't quite say clearly how far it's intended to go, and if that could be made clear and possibly some commitment to it's being strengthened in guidance or what have you, I think would be helpful to those who are looking at the bill with interest. As Elaine said, the other amendments that she's put forward are add-ons, if you like. Once you have Amendment 2 in place, the rest of them sort of follow, just to tighten it up and to strengthen it in line with the evidence that we heard during the consultation. Around the issue of interested parties, there's lots of legislation that goes through without clear definitions on the face of the bill exactly what every aspect of it means, and in the guidance that you find out, and that can be negotiated, that can be discussed, it can be added to as things move forward. So to have this on the bill doesn't necessarily create a problem. It just creates an environment around which the definitions of what an interested party could be clarified in guidance. Amendment 2C, I know there are concerns about the report coming next year, but as has been mentioned, a lot of this information has been collected. It's already known. It's just not in the bill and it's not covered by the bill. Therefore, a report to be produced in 2013, if we were to pass the bill this year, this month, it would give it until December next year. You would still be within 2013. And I don't believe that it's beyond the ability of the government to pull together a report in a year based on a lot of evidence which already exists. And Amendment 2D, once that information has already started to be progressed, annual reporting wouldn't be such a problem. It would be an ongoing matter which would just be adding and building on to what already exists. So I just don't see why there would be a huge issue in having the amendments that Elaine has put forward added to the bill for clarification and then expanded in relation to either regulations or guidance that might follow their inclusion in the bill. And I know we're not going to discuss item 9, but just one point on it, Convener.
Well, you can debate it and talk to it, you just can't move it.
Can't move it. It would be that, if bodies were to be added to the, or there was a period in which there were no issues to be added, then it's better to know that there is nothing to be added than to be left in a position where we don't know whether there have been trusts or alios created that could come under the remit of the bill, but we don't know whether they do or not. So to say that we shouldn't have that clarification just because there might not have been anything that requires to be added doesn't seem to me to be a particularly strong argument for rejecting the possibility of adding all the other ones in other subsequent years that would be added.
Okay. Jamie?
Thank you, Convener. Can I join with others in welcoming Amendment 2? I think it is useful to have a degree of clarity in how these matters can be consulted upon, reported on and acted upon. I think we should listen closely to what the Cabinet Secretary is saying in respect of Amendment 2C. And I should say I do welcome the fact that Elaine Murray has brought forward these amendments, because I think it is useful to debate some of the detail. But just because the date is set sometime in the future, I think the Cabinet Secretary has been quite clear, does not preclude the prospect for action earlier. And indeed, there has been a commitment for that, and we're going to hear some of the detail at stage 3. So I think if we take that in good faith, I think we should. I'm not convinced of the necessity for Amendment 2C, and I've got much the same feeling in terms of 2D. I do wonder if a report every year might be somewhat onerous and not allow for adequate scrutiny. But I'm absolutely no doubt that the dialogue on the specific details will continue, but at this stage I'm not convinced of the necessity of these particular amendments.
Okay, thank you very much. Cabinet Secretary, to wind up on Amendment 2.
Can I thank Elaine Murray for bringing the amendments and for all members who have contributed. I actually think this is a very worthwhile debate, because there's no absolute right and wrongs in terms of the timescales and who you consult. It's about trying to get the legislation proportionate and balanced so that it's doing the job it's designed to do. If I can just take some of the issues that have been raised. I'll start with some of the timescale issues, and firstly the provision in Amendment 2 that would see a first report laid in 2016. I've got sympathy with some of the comments that have been made that that's too far into the future, particularly in light of how long a period the Act has already been in existence. I do think doing it next year would be going too far in the other direction, but I am happy to give further consideration to whether we could bring that forward a year. I was struck by John Mason's point that we should perhaps be looking to bring it into this session of the Parliament, so I've got a lot of sympathy with that, and if Amendment 2 is passed today, I will give consideration to an amendment at stage 3 that would perhaps bring 2016 to 2015. The other point I would make, which even if we were sticking at 2016, I would hope would give some reassurance. It's not about setting a date in a vacuum, if you like, and nobody knows whether the power to introduce an order is going to be used or not. I have given the commitment that there will be an order, so by the time we get to 2016, we will have seen the first order introduced. But nevertheless, the points are well made, so I'm happy to give that further consideration in advance of stage 2. Similarly, in terms of the timescale for regular reporting, which we've set at stage 3, and we've done that because we think it strikes the right balance. I do think, and I strongly think, annual reporting is too frequent and just doesn't allow for proper consideration of orders. It wouldn't give any real timescale for a committee to scrutinise an order before the next report was due. So I do think that is too soon. 3 years feels right to me, but I've heard people say 2 years might be a better balance. I received a letter, as I'm sure the committee did, from the Information Commissioner yesterday, suggesting 2 years might be a better balance, and I think it's incumbent on me to give that proper consideration. So again, I'm happy to say to the committee, if we pass Amendment 2 today, I will consider bringing forward a further amendment at stage 3 that would change 3 years to 2 years. I'm not giving an absolute commitment to doing that, but I'm certainly giving a commitment to considering it. If we look at the issue about who's consulted, again, what Amendment 2 is trying to do is strike the right balance. The balance between being sufficiently focused in a consultation, because you've got a whole plethora of organisations that could be brought into the ambit of FOI. The same reach of consultation will not necessarily be appropriate for every single one of them, and I don't think necessarily a full public consultation in every instance is proportionate or necessary. But equally, the current wording of the Act, I think, is too narrow. So what we've tried to do here is strike a balance between being sufficiently focused while allowing enough scope to consult with, as required, for example, the consumers and users of organisations. I also think it is inconceivable that the Campaign for Freedom of Information wouldn't be considered an appropriate body to consult in any consultation about extension of the Act. Michael McMahon makes a point about the wording of the Act being fleshed out in guidance, and I'm certainly happy to consider how that could be done to make it clearer the kind of organisations we were talking about in specific circumstances. I think that might be a useful compromise. I guess my kind of final comment here would be to ask Elaine Murray if she was minded to not press her amendments today. There is a willingness in my part to have a further discussion with her around how Amendment 2 could be further amended at stage 3 to incorporate some of the key points that have been made, as I say, specifically around some of these timescales. And I'd be happy to ask my officials to have a direct conversation with Elaine in advance of the deadline for stage 3 amendments to see if we could come to some common ground around how what I think Amendment 2 does in strengthening the Act could be further strengthened in some of the ways that we've spoken about.
Okay, Elaine Murray, to wind up and press or withdraw Amendment 2A.
I'm very happy to receive the Cabinet Secretary's assurances and the offer of further discussion. I think that in bringing these amendments forward at this stage was indeed to hear some of the concerns, to look at how those could be resolved, and to identify whether there are particular problems in wording and so on, which these amendments might present, but could be resolved later on. So I'm very happy not at this stage to press my amendments to Amendment 2, but to support Amendment 2, but on the understanding that there will be further discussion to try to achieve some of the aims of that. In terms of Amendment 9, obviously that cannot be pressed at the moment. But again, I think because, and I do very much applaud the legislation team for the work that they did in trying to interpret that policy intention, there are clearly still some issues around that, but it is probably something that needs to be revisited perhaps at stage 3. So I won't be pressing the amendment.
We still have to go through the order, so we can't, on block, decide not to press any of them. So Elaine has made clear that she's not going to press 2A. Are we agreed? The amendment is not pressed. I call Amendment 2B in the name of Elaine Murray, already debated with Amendment 2.
Not moved.
Move or not move? Not moved. The question is Amendment 2C in the name of Elaine Murray, already debated with Amendment 2. Elaine Murray, to move or not move? Not moved. The question is Amendment 2D in the name of Elaine Murray, already debated with Amendment 2. To move or not to move?
Not moved.
The question that Amendment 2E in the name of Elaine Murray, already debated with Amendment 2. Move or not to move?
Not moved.
And the question is that Amendment 2F in the name of Elaine Murray, already debated with Amendment 2. To move or not to move?
Not moved.
Not to move. And Minister, to press or withdraw Amendment 2?
Press.
The question is that Amendment 2 be agreed to. Are we all agreed?
Yes.
We are indeed. Okay, and we cannot move Amendment 9. So we therefore move on to Amendment 10 in the name of Elaine Murray, grouped with Amendment 11. So I ask Elaine Murray to move Amendment 10 and speak to all amendments in the group.
Thank you very much, Convener. At the time the Freedom of Information Act was passed in 2002, it was expected that the public's rights under the Freedom of Information Act would be exercised in relation to current bodies as well as bodies created in the future that were delivering public services or services of a public nature. These provisions are encompassed in sections 3, 6 and 7 of the Act, although the latter refers to the right of access to information only in respect of the information held by the authority that relates to the public service or services of a public nature. However, since the passage of the Act, many public services have been moved to bodies not covered by the Freedom of Information Act, such as arm's length external organisations, also known as ALIOs, or indeed through council house stock transfer to registered social landlords. This amendment seeks to place the duty back on the public body, which creates the new body or transfers the function or service to another body not covered by the Freedom of Information Act. If this amendment is agreed, in the case of future such transfers, it wouldn't be retrospective, it would be in future transfers. Scottish ministers would not have to readmit these transferred bodies retrospectively through the use of this Section 5 power. The duty instead would rest with the public body to ensure that the right to freedom of information remains. The public authority would therefore be required to provide information on the services it had transferred under the Freedom of Information Act. Amendment 11 is similar to Amendment 10, but it refers to public sector contracts exceeding the value of £1 million. The duty to provide information again remains with the public authority rather than transfers to the contractor. This maintains the simplicity of the freedom of information process. Members of the public can make a request. It is not even necessary to mention the Act, and if dissatisfied with the answer, they may refer their complaint to the Office of the Scottish Information Commissioner. This is now a fairly familiar process, and information about public services or those of a public nature will be associated with a public authority, such as a health board or local authority, rather than with the individual contractor providing the service. The simple solution with regard to the provision of information about public sector contracts is therefore, I believe, to retain the freedom of information right with the public authority rather than transfer it to the contractor, and therefore that members of the public can seek that information through the commissioning local public authority. And I move Amendment 10.
Thank you. John Mason.
Thanks, Convener. I mean, again, I've got sympathy with what I think Elaine Murray is seeking to do. I just feel, number 10, it does become quite cumbersome. I mean, given that the whole way the Act is set up is that we, or the government, whatever, list the organisations that are included, to kind of then do it in this roundabout way, which would have the effect, for example, with Glasgow City Council, which concerns me, of chopping bits of itself off and allowing them effectively to leave freedom of information. It puts the onus back onto the council in that case to include them. But I still find that a bit unsatisfactory compared to actually having the individual organisations listed. I think if the Act had originally been set up that way, as the same argument as with the Purpose Clause, then that would be fair enough. But I do wonder, I'll be interested to see what the Cabinet Secretary says, but I do wonder if that is not rather a roundabout kind of route, although it might be marginally quicker. On 11, I suppose I've got slightly more sympathy because I don't think these contracts would be covered at all, normally speaking, because the organisations, assuming they're private sector, would not be included under FOI normally, but it would be for a specific contract. And I believe this kind of thing has been done in other countries, but I'm happy to listen to what the Cabinet Secretary says on that.
Cabinet Secretary?
Again, I'm not lacking in sympathy for these amendments, and actually there's a great deal of attraction in putting an obligation on public bodies, not least because it takes the obligation away from the Scottish Government to some extent. So I am attracted to what these amendments are trying to do. I just struggle with how by amending the Act in this way we achieve the objective that I think Elaine Murray is aiming at here. I certainly have been thinking about the ways in which this could be done. I'm certainly happy to continue thinking about that, but I really don't believe these amendments achieve the aim. Firstly, it's not clear to me how the provisions are put into effect in practice once the statutory bit of the work is done. It's not clear how it would be regulated or enforced. The Freedom of Information Act has got very clearly understood and crucially enforceable rights. What these amendments seem to be saying is that every public authority would be able to make its own arrangements. What would the terms of these arrangements be? I think there is potential for huge inconsistency between different public authorities. I'm not sure how such arrangements would then have the equivalent to the force of statute if the arrangements themselves are not embedded in statute. What right, for example, would a member of the public have to ensure compliance as against a person who's not a public authority and with whom they've got no relationship? I do think, for the reasons John Mason outlined, that we're trying to bolt something on or do something by the back door, we run the risk of creating considerable confusion when what we have just now, however imperfect and however badly in need of extension it might be, we've got an Act that is simple, straightforward, the public have a great degree of understanding of it, and it is enforceable. There's a clear route to enforceability. The Freedom of Information Act, as I say, is simple in that it applies to bodies clearly named in the Act or bodies wholly owned by public authorities. The power to extend by designating bodies and ultimately to give legal certainty as to the coverage of the Act, I think should remain within the scheme of the existing Act with the exercise of powers by Minister subject to parliamentary scrutiny. I do think the proper way to address extending the application of the Act is through the use of Section 5. It hasn't been used, and we all understand the frustration about that, but I still think, notwithstanding that, that is the correct route to extend the Act. Amendment 11 also seems to me to be quite unclear as to whether we're concerned with information held on behalf of a public authority, in which case it's already subject to the Act, or information otherwise held by the contractor. The amendment provides that the relevant information is information relating to the performance of the contract, but that meaning is not very precise or clear. Contracts can cover a broad range of activities, including functions of an authority. Information on performance of a contract might, for example, cover more than simply information on the performance of a function. Also, defining the information in this way risks straying into areas that perhaps aren't appropriate in terms of coverage of the Act. Of particular practical concern, though, the provision could only be made effective by the authority imposing contractual obligations on the contractor in order to ensure that in the event of a request for information, the contractor and those further down the supply chain would provide it. Again, that immediately raises issues of enforcement. How would that be enforced in practice? There's also an issue of the relationship with the provisions in the Public Records Scotland Act 2011, which I can go into in more detail if the committee wants, but I simply raise that as an issue at the moment. My fundamental view of these amendments is, yes, sympathy, but coming back to the view that the Act has a mechanism for extending its coverage. The fact that that mechanism hasn't yet been used doesn't mean that mechanism is not fit for purpose. It just means that we've got to use it, and I've already given a commitment to do so. I am willing to have a discussion with Elaine Murray about whether there is anything we could progress here. I don't want to raise expectations, because I do think this is incredibly difficult for the reasons John Mason outlined. I'm happy to have the discussion, though, to see if there is any common ground that we could get to in advance of stage 3. But my fundamental view, I think, is that what we need to do is use Section 5, not look at different mechanisms with lots of imperfections just because of the frustration that Section 5 hasn't yet been used. So I would ask Elaine Murray not to press Amendments 10 and 11.
For a little clarification in respect of Amendment 11, in terms of the use of the Section 5 power, that in the case of large-scale public contracts, can that be resolved by designation under Section 5?
Yes, my understanding is that it could be
through
designating. Yes,
yeah, Jim Wallace intended to do it, but I'm just
exactly.
not clear about that.
It could be. I think probably Amendment 11 is where I would certainly welcome further discussion about, the aims of that and how that could be covered by Section 5, or whether there is something more we could do. So, as I say, I'd be happy to have that discussion. I'm not giving any guarantees that that discussion, in the interest of being frank with the committee, that discussion will lead to government amendments at stage 3. But I understand what Elaine Murray is trying to achieve here. I just think the route to achieving it is the existing mechanism in the Act, and actually using that rather than trying to create mechanisms that are just being created because there's a frustration that Section 5 hasn't been used.
Okay, Elaine Murray to wind up and press to withdraw her amendments.
Thank you, Convener. I think in terms of Amendment 10, the intention was maybe to simplify it so that ministers weren't continually having to make Section 5 orders as councils or other bodies created ALIOs, that there wasn't a need to then keep on designating them, bringing them back in. That it was a way of trying to circumvent that problem. But I take on board what you've been saying in terms of this is because it's a different mechanism to that which actually exists within the Act already, that it's maybe not appropriate to bring it back in at this stage. I'm also interested. I do think there is a significant issue about contracts which involve large amounts of public money and the accountability of the ways in which those contracts are performed. Therefore, I'm happy not to withdraw Amendment 10 at the moment, if the committee is sympathetic to that, and I won't move Amendment 11, but I certainly will be interested in further discussion as to how the intention of Amendment 11 might be incorporated through the Section 5 power.
Thank you. The question is that Amendment 10 be agreed. Are we all agreed?
I'm going to withdraw it.
Oh, sorry, I thought you were saying you were going to move 10 and not 11.
No,
That's what you just said.
No, I've caused confusion in that case.
Apologies.
No, I didn't really intend. I have a concern about. I hear what the Cabinet Secretary is saying about. Although my intention was to try and circumvent the necessity of ministers to keep coming back using and exercising Section 5 power, that there may be a problem in doing so in adopting a different mechanism through amendment of the Act. So I'm happy to withdraw that amendment if the committee is condemned to do so.
So Amendment 10 is withdrawn, colleagues, unless anyone else wishes to press it, of course. I call Amendment 11 in the name of Elaine Murray, already debated with Amendment 10. Elaine Murray to move or not move?
Not moved.
Not moved. The question is that Section 2 be agreed. Are we all agreed?
Yes.
We are all agreed. The question is that Section 3 be agreed. Are we all agreed?
Yes.
Okay. I call Amendment 3 in the name of the Cabinet Secretary, group with Amendments 4, 5 and 6. I'd ask the Cabinet Secretary to move Amendment 3 and to speak to all other amendments in the group.
These amendments are technical, and I apologise to the committee for that. I would also stress at the outset they're not changing the policy intention of the bill. They are simply making sure that the bill is drafted in a way that can fulfil the policy intention of the bill. Members are aware that in 2009 the government took the decision to open its files containing historical information at 15 years rather than 30 years. Some 12,000 files have been opened as a result of that by the National Records of Scotland, and that move has contributed to greater awareness and understanding of Scottish affairs far earlier than would originally have been the case. So it's been a positive experience, and I think also a tangible sign of the commitment in Scotland to progressive freedom of information legislation in its broadest sense. The decision to halve the release period, though so far has been a decision of policy, not a matter of law. And as we discussed at earlier stages of the process, a simple reduction by means of the Section 59, subsection 1, order-making power of the 30-year lifespan to 15 years for all relevant records is not considered appropriate in all cases, but the present legislation doesn't allow for the creation of separate provision for particular exemptions in different types of record. The bill as it currently stands seeks to provide greater flexibility in respect of the order-making power. For example, it allows for the making of different provisions for records of different descriptions and for different individual exemptions. However, it's become apparent that the provisions of the bill don't contain sufficient veeries to enable the intended policy objective to be met. Government has already publicly set out its intentions in respect of all 30 years exemptions. The aim is to bring forward an order in early course to reduce the lifespan of most relevant exemptions to 15 years. But to address sensitivities around confidentiality, the Section 36 exemption is likely to remain at 30 years. In addition, it's proposed that the rules in relation to the exemption concerning communications with Her Majesty, members of the royal family and royal household, should be capable of being amended by order to take into account a particular event. Event is left undefined so as to confer a measure of flexibility to link the period to particular circumstances, such as the death of a relevant member of the royal family. And the proposal is that in these cases, the specified period for historical records should be the later of 20 years after the creation of a record or 5 years after the date of the death of the relevant member of the royal family. However, as members hopefully will be following me here, that could potentially increase the lifespan of the exemption to over 30 years. For example, if somebody dies 30 years from now and then there is a 5 years after the death, that could take it to 35 years. The current order-making power, though, only enables a reduction in the period of time at which point a record is classified as historical in relation to the royal exemption. So in order to deliver the policy intention, and the policy intentions are not changing, Amendment 3 further modifies the order-making power, allowing for greater variation in the definition of historical record. And the power is framed in a way to enable an order to make the necessary provision as to the rules around the meaning of historical period, for example, to cover different types of records and different time periods for particular records. In relation to the exemption in section 41A, it allows the period to start either with the date of the creation of the record or another event such as a death. But in either of these cases, the period specified mustn't be more than 30 years after that starting point. For exemptions other than section 41A, the maximum period that can be specified in an order will continue to be 30 years from the creation of the record. Amendments 4 to 6 make consequential changes, and Amendment 5 allows an order to make ancillary provision to ensure the smooth transition from one set of rules to another. I can understand that there might be concerns about legislating for the possibility of increasing as well as reducing the period of time at which a record becomes historical, but we've always been very clear about our intentions in this regard, which are very specific to the royal exemption. I also would note that in his response to the consultation on the draft bill, the former Information Commissioner explicitly stated that were the exemption to remain subject to consideration of the public interest, which our earlier amendment today ensures will be the case, he could accept the revised lifespan of section 41A. And as a result of Amendment 1, as I said, that will be the case. And lastly, Convener, I would also just point out that the relevant power will remain subject to affirmative procedure in the Parliament. That is the effect of Amendment 6. Finally, the order putting into effect the Government's proposals will be subject to further consultation. So I hope the committee stayed with me during what at times was a technical explanation, and I move Amendment 3.
I think it was all pretty straightforward, really.
Difficult to understand.
No members wish to comment on this. Would you wish to wind up further?
No, I would simply ask the committee to support the amendments.
Okay, the question is that Amendment 3 be agreed to. Are we all agreed?
Yes.
Members are agreed. I'd like to call Amendments 4, 5 and 6 on the name of the Cabinet Secretary and all previously debated. I'd like to invite the Minister to move Amendments 4 to 6 on block.
Moved.
I'd like to ask whether any member objects to a single question being put on Amendments 4 to 6. No member objects. Therefore, the question is that Amendments 4 to 6 are agreed to. Are we all agreed?
Yes.
Thank you. The question is that Section 4 be agreed to. Are we all agreed?
Yes.
The question is that Sections 5 to 8 be agreed to. Are we all agreed?
Yes.
We are. I'd like to call Amendment 7 in the name of the Minister, already debated with Amendment 2. Minister, can you move formally?
Moved.
The question is that Amendment 7 be agreed to. Are we all agreed?
Yes.
We are agreed. And the question is that the long title be agreed to. Are we all agreed?
Yes.
We are all agreed. And I'm pleased to say that that ends Stage 2 consideration of the bill. I'd like to thank the Cabinet Secretary for her attendance here today. Members should note that the bill will now be reprinted as amended and be available tomorrow morning. The Parliament has not determined when Stage 3 will take place, but members can now lodge Stage 3 amendments with the legislation team. Members will be informed of the deadline for amendments once it has been determined. Last week the committee agreed to take the next item in private, and at the start of today's meeting it was agreed to take items 4 and 5 in private. I therefore now close the public meeting to allow the public and official report to leave, and I'll also call a natural break for committee until 10:50. Thank you.